Are you curious on how to expunge your criminal record in Oklahoma? Watch this video to learn how. Seeking an expungement of your criminal record in Oklahoma can seem like a daunting or confusing task. However, our team of fierce advocates at Cannon Associates have worked on a specific process to make the procedure easy for you and your loved ones. In order to identify whether or not you qualify for expungement, it's important to review the statutes or to meet with an experienced Oklahoma expungement attorney. Our team here at Cannon Associates has worked with many clients to evaluate whether or not they qualify. There are two types of expungement: a Section 18, or the total package expungement of both your criminal case and your arrest record. In order to qualify for this, you must have been off of your dismissed case or deferred sentence for a set period of time, typically 5 years. Conversely, for a 991 section expungement, which only changes how your case is reflected on the court records to dismissed, does not expunge the entire record, does not expunge your arrest record, it is easier to qualify for that type of an expungement. So the process of how to expunge a case in Oklahoma. The first step is to think about what an expungement is in Oklahoma law. It is closer to a civil case or a lawsuit than it is something you do after your criminal case. In order to begin the process, you must draft a petition for expungement and file it in the appropriate district court, which would be where your case took place originally. If you have a case in Oklahoma County and Canadian County and other counties around across the state, as many of our clients have, we must file, or you must file, a petition for expungement, in each case identifying the correct case number. Think of an expungement as more like a lawsuit where you're suing the state agencies that have your records than it is something you're doing in your criminal case. The petition for expungement is filed in the court clerk's office. You pay a filing fee, and that's when the exciting part begins. You must take a copy of your file stamped petition and serve it, or give a proper copy of it with notice of the hearing date in front of the judge on your expungement case, to every interested party. In most instances, this involves at least the district attorney's office that prosecuted your case, the Oklahoma State Bureau of Investigations, or OSBI. If it is a case involving a DUI or a traffic stop arrest, then the Department of Public Safety, and the law enforcement agency that was involved in your initial arrest. So typically you're dealing with at least 4 agencies that you must find the registered agent for, or general counsel's office to send them a certified copy of the petition for expungement and ensure that they receive that copy. The next important step in the process is a hearing. It's not as simple as file a petition, case closed. You'll be assigned a judge in your case, and you must get a hearing date from that judge when your request to have your expungement ordered or your case sealed is heard by that court. That hearing date will typically be 2 weeks to 45 days out from the date that you file your case. You must give notice to all the interested parties of that hearing date and then wait for your day in court. We've found oftentimes with the state agencies that we work with that, based on the relationship and review of the case, they will agree to sign an order of expungement, which can result in that court date being canceled. If we were able, or if you were able, to get all the involved parties to execute an order waiving their appearance, waiving the right to be heard, or objecting to your request for an expungement, then you can take that signed agreed order to the court. Once we have all of the signed copies from all the involved parties, we can take that to the court and present an order for expungement and ask the court to sign that for us on your behalf. Conversely, if one or multiple parties won't agree, then you'll have a hearing in front of the judge on the merits, where you or your hopefully fierce advocate from Cannon Associates will fight for you and tell the court why you should be granted the expungement that you're asking for. Conversely, or alternatively, the other side of the case, whether it's the victim or law enforcement or the district attorney's office or OSBI or the Department of Public Safety or some other interested party, may have a reason they object to your request for an expungement. They can come and plead their position, why it is in the interest of the public that your records not be sealed, and the court will make a decision on what will happen. Once the court has reached a decision, which we hope is in your favor, then that signed order is taken back to the court clerk's office. That signed order is filed, and we receive certified copies, which is stamped and signed by the court clerk's office, and provide a certified copy to every interested party that may have your records. Once that's happened, those agencies have to abide by the district court order, and your records will be expunged and sealed. Hope this video has been helpful explaining to you the process to seek an expungement in the state of Oklahoma. We encourage you to reach out to us if you have any questions about this process or to see whether you qualify. You're welcome to visit our website for resources and more details on expungement in Oklahoma. And I encourage you to click this button at the bottom of the screen to subscribe to our channel.